Just an overview of this project. This project involves not just this online tool that allows applicants to begin that process of seeking petitions for protection in the safety of their homes, in the safety of the public library, on their smartphone, on their iPad, but it also involves a series of changes in the law, the court rules, and the process itself to make all of this work. As I said in my introduction, this went live on January 1st of 2020, and we still are working out some of the bugs, but it is very, very effective and it's working, which again is just real exciting to everyone who's been involved in this project. This presentation is going to cover 3 different facets of the program. First, I'm going to take you through how does an applicant go online to create the petition for protection. Judge Hancock is going to cover the process of filing the petition and then getting it served. And then we'll take your questions. So I'm going to turn it over now to Judge Hancock.
Thank you so much, Sheila. I also want to echo what Ms. Polk said. This was no doubt in the trenches, people working very hard to get this into place. And Ms. Polk was instrumental in doing that. She's not joking when she says that we were working on this, people were working on this throughout Christmas and the New Year. And we've had now 8 months of this system. And while there are still bugs, it is far better system than we had before. And there have been minuscule problems in comparison to how this helps victims and the process. And so it's just amazing. We're going to go through it. What I'm going to do today is I'm going to go through the law, but I'm also going to give you some tips based on what we have seen in the courts regarding the filing of these petitions and how a lot of it plays out. And I really, really want you to ask me questions because the judges, we realize how difficult this is for y'all. And it's very hard to walk into a courthouse with this situation, whether it's an order of protection, injunction. We do realize how difficult it is for you to do this process, come to a courthouse, walk into a courtroom. It takes an enormous amount of courage for you all to get this done. So we do understand that. I am going to go through the law. There has been some changes in the law, but I think more important for me today is for you all, if you have questions, please ask me. The protective order procedures, there's a lot of history behind protective orders and injunctions against harassment. You will see on your screen with this slide that there are orders of protection. The numbers next to the slides are the statute numbers. But in total, these procedures for all of these issues are governed by the rules of protective order procedure, which I'm also going to go over. Next slide. The orders of protection are governed by 133602, which is a criminal statute, and Rule 23 of the Rules of Protective Order Procedure. Orders of protection require a relationship between, and we call it the relationship test, and domestic violence. They may be granted to prevent a person from engaging in acts of domestic violence. I get a lot of questions about what constitutes domestic violence, but the first test you have to pass is whether or not there is a relationship. And you can see in this slide that it's defined, pretty broadly defined, and those relationships are listed on here. We do have individuals who go a little bit beyond this relationship test. The thing to remember with AZPOINT is if you fill out the order of protection form and you don't have the relationship test, we have to dismiss it, and you have to go back into the portal to file an injunction against harassment. The very most important thing is that we have to find that there is reasonable cause to believe that the defendant has committed an act of domestic violence in the past year or will commit an act of domestic violence. We also realize that in most of these situations, there is a long history of domestic violence. We can't order an order of protection based on an incident that happened 3 years ago. Again, we completely understand that this is usually going on for many years, but we have to be able to find that there has been an act in the past year or that the individual will commit an act of domestic violence. Next slide. Injunctions against, let me just say one other thing. Orders of protection go before a family court judge. They do not go before other judges unless somehow we are not here. Injunctions against harassment are supposed to go before a civil judge. Often we do handle those as well, but those are civil matters, and we'll get to more about that later. So injunctions against harassment do not require a special relationship, and they require a series of harassing events. This is a change to the law recently. So we used to require 2 or more harassing events. Now it is just a series of harassing events. And the thought behind that change in the law was that picture the individual who receives 60, 70, 80 text messages or phone calls in one day. And so the thought behind that was that it could be a series of acts, not just 2. There's also the provision of 1 act of sexual violence against the plaintiff during the preceding year. The standard, and then also there's good, and this catch-all that's in all of these statutes is great or irreparable harm. So that's an or. So if there is great or irreparable harm, we can find that under in any injunction against harassment, we can also find that. This is a situation usually where we have neighbors, or oftentimes it can be a new girlfriend against ex-wife. We see that a lot. So those are the series of harassing events that we normally see in injunctions against harassment. Next slide. These are injunctions regarding workplace harassment. In a workplace and 1 harassing event, this is where the employer can come to get an injunction against someone who is coming on the premises. The employer, workplace, the employees, or any other person who is on the employer's property, place of business, or performing official work duties. Again, the standard is the reasonable evidence of workplace harassment. This is where we mostly see former employees, or we also have seen employee against employee. And so this is the employer that can come to get an injunction against people working in the business. I don't see these very often, but I have seen a few of these. Next slide. All right. So this is an important slide that I want to go over. We will see you the same day, no question. And at least here in Yavapai County. And most of these are issued ex parte, which means that I'm going to see you in my court and the other person is not going to be here. So I will make a decision about whether to issue the order of protection that same day. We will try our best to see you within a couple of hours. So that's important. I'm going to talk about that later. The defendant is entitled to a hearing. They get to ask for one hearing only. We have to hold that hearing within 10 days If we grant the plaintiff exclusive use of a home, 5 days. The burden of proof on the plaintiff is preponderance of the evidence. That means that the plaintiff has to prove his or her case by 51%. Orders of protection stay in place for 1 year unless they are dismissed at a contested hearing. There is also the possibility of an order of protection being modified. Orders of protection can be issued from any court in the state. It doesn't matter. It can go to a municipal court. It can go to a justice of the peace. This next line is pretty important. I'm going to go over that a little bit later in detail as well. Orders of protection take precedent over any case, including parenting time orders. And the next line as well, they cannot contain provisions regarding legal decision-making or parenting time. The important thing to understand about that is that if you request children to be on an order of protection, that provides for a problematic situation. So, and I can ask, there's another slide, I'm going to go over this a little more, but the problem with putting children on orders of protection is that it basically says then that mother or father, whichever one is the defendant, will not see these children for a year. And I'll go over that a little later, but rarely do we put children on orders of protection. That is not to say that we don't, because we do. In fact, I had 2 last week. But keep in mind that we are not allowed to put legal decision-making or parenting time in an order of protection. But if children are on the order of protection, that is a de facto legal decision-making or parenting time order. So we're very careful about that. All right, next slide. And actually you can forward to where it has the welcome AZPOINT, or is that's yours, Sheila?
This is mine, thank you.
You're welcome.
I'm now going to take you into this tool. It is located at www.azpoint.azcourts.gov. But if you're trying to find this tool, you can just Google AZPOINT and it will take you right to this website. And what I'm going to do in this portion of the presentation is take you into the website and show you how an applicant would start the petition. So once somebody has located this website, this is the home screen. It says, "Welcome to AZPOINT." And I'm just going to read to you the first couple of paragraphs so you see what an applicant, this is how they're being informed about this online tool and how it can help them. Welcome to AZPOINT, through an interview in this portal, you can quickly and accurately fill out the forms that are needed to request an order of protection at an Arizona court. An order of protection is a court order that is issued to stop a person from committing domestic violence or from contacting other people protected by the order. The portal will also help you figure out whether you, the plaintiff, and the person from whom you are seeking protection, or the defendant, have a qualifying relationship for an order of protection. And that's what Judge Hancock specifically talked about, the need for that special relationship. You may also use this portal if you're asking for protection on behalf of another person, either a minor of whom you are the parent, guardian, or legal custodian, or an adult who is temporarily or permanently unable to request an order. Even if you are asking for protection on behalf of another person, you are still the plaintiff. The other person's name will also appear on another part of the petition. And then there's 2 bullet points that are very important. Again, emphasizing trying to steer the applicant to the correct protective order that they're seeking. So the first is an asterisk that says, if you do not have a qualifying relationship for an order of protection, you may be eligible to apply for an injunction against harassment. You must be able to allege one instance of sexual violence or at least 2 incidents during the past year during which the defendant harassed you. And then if you are an employer seeking protection of your business or employees, you may apply for an injunction against workplace harassment based on a single act or a series of acts of harassment. And one of the features that I love about this online tool is it takes the applicant through an interview process, and as you will see, steers the applicant to the correct protective order. So the first step that a new user has to do is to create an account. That's this red arrow here, and it takes you, you will click on create an account and fill out some information, and now the person has an account that will be saved. One thing I want to point out is that to me, again, there's wonderful features in this program, but I love the fact that an applicant can fill this out anywhere. This is in contrast to the old days when you had to go to the courthouse and you had to fill out the paperwork, and you know, it was all happening so fast and you didn't have the time to really think it through or necessarily get help. This tool, this online tool, allows you to create that account, and you can work on it over a 90-day period. Your account will stay active. And so if you're in a situation where your abuser is still in the home, you might only have specific periods of time that you can work on it, create it, get out of it. Perhaps you fled the home, you can go to the public library, you can go to a friend's house. Since it's internet-based, it's accessible from anywhere. And it's accessible from any tool, whether it's a smartphone, an iPad, a laptop, a computer. They have tried to make it 100% accessible. So after you create the account, then the next thing that happens is you now have a login. And every time you go back to AZPOINT, you just simply log in and it picks up wherever you last left off. This is a wonderful feature over here. To the right of the screen, you can see something. It's a big red button and it says safety button on it. This appears on every single screen of AZPOINT, and it's really quite ingenious. It is specifically for the safety of the applicant. So if the applicant is filling this out and suddenly her abuser walks into the room, all he or she has to do is click on that safety button. It immediately takes you out of AZPOINT and it immediately erases the browsing history. So if somebody wanted to get on your computer and try to figure out, well, you know, what were you doing when I walked into the room? What will come up is it's actually some recipes, some cooking recipes, and there's some other different options as well. But it hides that history from somebody who's trying to see what you were doing. So that safety button appears on every single screen and is always there for somebody to quickly click on, and it automatically saves all the work that you had done up to that point. So when you click on that safety button, you don't lose any of the work that you've done. The information is saved for 90 days, and this notification comes up from the very beginning, just letting the applicant know that the portal saves the information for 90 days. At any time during this 90-day period, you may take the next step of filing your petition at an Arizona court. Until you file your petition at a court, you will be able to return here to update your information as necessary. And that's another really nice feature. You think about it for a few days, you think, well, I want to change something. You can go back in, log into your account, you can add information, change information, and not until you actually submit this petition is that application considered complete. The information on this website also advises applicants to speak to a victim advocate before you file your petition. An advocate can help you make a safety plan and give you information about how an order of protection works and how it will be served on the defendant. This is a screen that just shows you that a petition within AZPOINT can be at various levels of completion. So the first example up here, it's applicant number 143. We gave the applicant the name of Smith. They're filing for an order of protection. And the system tells you your petition is complete. It is ready to submit. And even then, you can see over to the right of the screen, for that petition that appears to be complete, you still have the opportunity to revise it. You can click on instructions to learn more. You can print your application if you want a hard copy of it. The second entry is an example of an application that is in progress. So this example is applicant number 169. The person's name is Busted. They're seeking an order of protection. And it shows that this order of protection is in progress. And where that applicant left off is in entering incident history. And so the applicant just needs to click on continue and it'll take them right to the area where they left off. And then that last one is applicant 252. The name is Bobarino. It's an order of protection. And this is a petition that, actually I'm not, maybe Judge Hancock can help me out here what this would mean, and then you can click on instructions. It says petition XML accept with an XPA.
So that just, what that means is that if you come to the courthouse, the clerk can actually access your petition without you printing it out first. So that what that means is, I think the instructions say, when you clerk, I think it says clerk or something when you click on that. And that's the XML accept is the clerk can bring up your petition.
Excellent, thank you. And then again, for the applicant to understand, this will disappear if it goes untouched for 90 days. So we're keeping this application open for 90 days. But if the applicant doesn't come back to it, doesn't open it, then it is going to disappear after that 90-day period. This next screen shows you another really nice feature about AZPOINT, which is the hover feature. And so much of what is in this tool, you can get explanations for simply by hovering. It's a question mark, I blew it up here, but it's a question mark in a blue box. And if you just hover over wherever you are in the application, if you don't understand what they're asking for, most of it has been worked so that you can hover, the question mark will come up, you can click on it, and then it will give you instructions about what it's looking for. So that's a really nice feature as well. All right, so now we're on the screen that is about getting started. So we had the home screen, we had the first time applicant creating the account, we have the applicant coming back to the account to log in to work on it, and now this arrow is showing us that we are going to get started. We're going to take you through what the applicant would see in terms of the various screens, so you have an idea of what is being asked. And I think you'll see that this truly is like an interview. It's like sitting down with somebody, they're asking you questions, they're helping you fill out the forms. And when you don't understand, if this were a live interview, you'd be saying to the person, I don't understand, what are you looking for? What the applicant has is that hover button where it will tell us more specifically what we're looking for. So once you are ready to create a petition, the first thing you have to do is enter plaintiff information. And a lot of these are drop-down lists, which is, it's really nice. It kind of directs you. So the first thing is directing the applicant to select the option that applies to the relationship with the defendant. And as you know now, that's to help the applicant identify, is there that special relationship or not? So the options in the drop-down list are you married, past or present? Do you live together, past or present, as intimate partners? Do you have a romantic or sexual relationship, past or present? Are you a parent of a child in common? Is one party pregnant by the other? Are you related? In other words, are you a parent, grandparent, child, grandchild, brother, sister, including a step or an in-law? Do you live together, past or present, but you're not involved in an intimate, as an intimate partner? Are you dating, but you do not have a romantic or sexual relationship? And then other, you would need to specify. Then the online tool asks you specific information. Anywhere in this application, if there is a red asterisk, that means that that information is a required field. So this is simply asking your name, your date of birth, your preferred contact number, and then you enter that contact number. The court needs your contact information, as Judge Hancock will talk about in a little bit, and in particular for communication between the system and getting these served. And then the next screen is going to ask you about service. If this service is available, can the court text you, yes or no? Can the agency that will serve your order, can they text you, yes or no? What is your email address? You put in your email address, and then you can identify whether or not you want this email address to be kept confidential. And do you want to receive an email notification from the AZPOINT system? And this is where if you are helping somebody with safety planning, you really need to think about where they might be when they get a text or an email, and whether or not they would be in a safe place to be receiving this information. Then the system asks for your home address. This is a required field. Is your mailing address different from your home address? And in Arizona, the home address of the applicant is always confidential. Now the tool will ask you about your workplace if you're employed. So what is your work address? And do you want this work address to be kept confidential, yes or no? The next screen will ask about school addresses. So in particular, if there are children involved who are in school, where are they? The school addresses will be kept confidential. And is there any other address that you want to protect? And do you want this address kept confidential as well? So now the plaintiff has completed the plaintiff's information. The system next takes you to the piece of the portal where you're going to enter the defendant information, or the information about that person against whom you are seeking this protective order. It needs to know the name of the defendant's date of birth. Sometimes people may not know that information. And what's nice about this system is it allows you to tell the court that you don't exactly know the date of birth. So this is an estimated date of birth. Then the portal will ask, does the defendant live with you now? Yes or no. And then it wants the defendant's home address. So you fill in the defendant's home address. This is a required field. And next it wants to know the defendant's home phone number. If you have it, it's a good idea to supply it to the system. But if you don't know a phone number, then you can see here's a box where you can click that you just don't know. Now the system wants to know about the defendant's physical attributes. And of course, this is very helpful when getting defendants served with these protective orders. So the sex of the defendant's race, the defendant's ethnicity, and the defendant's height. Again, you may not know the exact height, and if you don't, if this is an estimate, then you would click that this is an estimated height. The defendant's race, as you go through the drop-down fields, what you would observe is that Hispanic is not an option when it comes to race. Hispanic falls under the category of ethnicity. And this is how the NCIC, or the National Criminal Information Center, processes this information, how they collect this information. That, of course, is the FBI's clearinghouse of crime data. But some people are a little bit confused about this when they see that there's not Hispanic. But just know that that is not one of the options under NCIC. However, the system then turns to defendant's ethnicity and asks specifically Hispanic or not Hispanic. The information the system wants to know about the defendant's height. Again, are you estimating or is this exact? And what is the defendant's weight? Is this the exact weight or are you estimating? The defendant's eye color, there's a drop-down list. What is the defendant's hair color? Again, there's a drop-down list. And then does the defendant have any distinguishing features? As you work your way through this online tool, you'll see that for as many entries as possible, the system has tried to provide drop-down lists. That makes it easier to convey the information to the next stage of the process. But there are opportunities to fill in, to just type in additional information. For example, on this screen, it wants to know specifically, does the defendant have any distinguishing features? And there are 3 boxes. The first one is, are there scars? And if yes, what's the location and the description? So in this example, we clicked yes, there's a scar. It's on his or her left eyebrow. The scar through the eyebrow so that there is no hair. You can also select other marks and where they're located. In this example, we said that on the defendant's right arm, there's a red birthmark. And then the next one is, are there tattoos? And if so, describe them and tell us where they're located. So in here we put, yes, there's a tattoo. It's on the defendant's chest and it is an eagle. And all of this helps, of course, identify the defendant. What is the defendant's work address? If employed, you may not know it. The applicant may not know it. So you have a box where you can check that you don't know it. But if you do, then you would fill in that information. And what are the defendant's work hours? You may not know. You can click the box. But it also allows comments. So in this example, we wrote, the defendant usually works this shift except Sundays when he works the morning shift. It specifically wants to know when are the defendant's days off. You may not know, or you can highlight, as you can see, any of the 7 days of the week. And in this example, we highlighted Friday and Saturday as the defendant's days off. And then the best day and time to find the defendant for service. These are fill-in boxes where the applicant can supply the court and process server with information. So here, for example, we wrote the best days and times at home. This person always watches The View in the morning, so weekday mornings are good. And what are the best days and time at work? We wrote, by way of example, Sunday mornings, never Tuesday, sometimes covers at another store. And then on the screen, it asks, are there other places where a defendant is likely to be there? And what are the days and times? And so by way of example, we wrote that the defendant always goes to his mom's house. We gave the address, and he always goes there for Sunday dinner at 6 p.m. The next screen asks for vehicle information about the defendant. Again, the applicant may not know, so you can just select you don't know vehicle information, but as much information as possible that an applicant can give, it certainly helps with obtaining the order and getting service. And then here's additional information. So is the defendant violent toward police? Is he or she a heavy drinker? Is he or she on probation or parole? Is he or she a drug user? And is he or she mentally ill? Does the defendant own or carry a weapon or firearm or other weapon? You can select yes, I don't know, or no. And does the defendant have a firearm or a weapon? And again, no, I don't know, or yes. And then the next question is, does the defendant need an interpreter, yes or no? So now we're going to turn it back over to Judge Hancock to talk about the orders of protection.
Thank you, Ms. Polk. And I just want to emphasize everything that Ms. Polk said about when you're filling out those forms. I also want to tell you that some of those questions are not on the form that the judges get. For example, it doesn't transmute to the petition that we see about whether or not they are a prohibited possessor. And this is, I think, what Ms. Polk and I were talking about there are some bugs. And so as I go through these next slides, I will tell you some things like there are questions you should expect to be asked. And I will go through that as well as I go through the petition. I really want everyone to know what to expect in the courtroom, because I think that's the part that is a little bit confusing for people when they come to court. All right, next slide. So if you have, and Ms. Polk went over where it says that you have to say whether or not you have a family court matter. There's a few different reasons for this. And please put it in there. It doesn't matter if you have it in another county or it's our county. The rules of protective order procedure require that an order of protection be transferred if there is a family court case. And the reason for that is that if we have your family court case, there's likely to be issues in your family court case, and we try as hard as possible to hear orders of protection or injunctions against harassment before the judge that has the family court case. And they are required to be transferred, an order of protection to be transferred to a family court. And so it's really vital that you put that information in your petition. Even if you don't, and you're at a justice court or a city court, they will likely ask you that. I always ask a few other questions, like, is the Department of Child Safety involved in your case? And whether or not you have sought an order of protection in another court. And there's a couple of different reasons for that. If DCS is involved, there might be what we call a dependency action. If there is a dependency action, then the juvenile court has to handle those cases. And so we try very hard to make sure that we're not making orders over other orders. If you did have a dependency action, the juvenile court should hear the order of protection. So expect to be asked some questions. I'm going to try as I go through this to tell you what possible questions you might be asked. Also, I neglected to do this, but there is such a thing as an emergency order of protection. Emergency orders of protection are when police are there, there's been a bad situation. We have a duty list of judges where if there is an emergency order of protection, the police can call the judge and get an emergency order of protection over the phone. Emergency orders of protection are good for 24 hours or the next business day until close of business. And so what happens is the police officer calls the judge, and the judge swears the police officer in, he tells the details, and you'll have a limited scope, essentially, emergency order of protection. Then you have to go to court the next business day to get actually a full order of protection. So if you have questions about that, let me know. We don't see those very much in Arizona, and that's because, well, at least in Yavapai County, because we have excellent law enforcement here, and usually they are figuring out the case. And under our law, most times someone's going to jail if there is a domestic violence incident. So we don't see those as often, but that is something that does happen. Okay, and again, next slide. This is also the same thing I was just talking about. And again, there will be some questions. Most of us also ask if the plaintiff has ever been arrested for domestic violence. That is simply to make sure that the plaintiff wasn't arrested last night for domestic violence. Believe it or not, that does happen. And whether or not the defendant has been arrested, there was a slide that Ms. Polk showed you that asked whether or not the defendant is a prohibited possessor. Those questions to the answers to those questions do not come to the judge. It's just not noted in right now. It's one of the bugs we are trying to work out. So just be expected to ask that. Next slide. And now we go to orders of protection in the portal. Next slide. This is, are there any other protective orders between you and the defendant? That will be asked of you. It does show up on the forms that we get. What I want you to understand about the rules of protective order procedure is that there is a rule that prohibits mutual orders of protection. And there's a difference between mutual order protection and cross petitions. They've changed the name of that, I'm gonna forget. So the rule that says no mutual order protection in the same case, there have been changes in the law. That rule was not changed, but that rule was in effect 2 years ago before they changed it. And that was meant to provide for no mutual orders of protection in a family law case. We used to consolidate protective orders into family law cases. We cannot do that anymore. And so that rule has not necessarily changed, but we do not allow mutual orders of protection. And so what normally happens is one party comes in and gets an order of protection and it is served, and then the other party comes in the next day and asks for an order of protection, which we normally do not grant. So for the advocates out there, I want you to understand that, because I know you get this question all the time from the people that are seeking your services. Next slide. This is the firearms. There's two parts to this. The firearms, which I think I've already talked about, but we are required to ask this when you have your hearing. The law actually says that you can say it in the petition or you can testify to firearms. And I know this says firearms, but the statute and the rules also say weapons. And so I've seen people come in and talk about knives, hatchets, all kinds of things, bow and arrow. And so we will ask you that question. We're required to ask you that question. New part of the statute that I personally like a lot is that now the defendant can be ordered to stay away from animals kept or held by you. And then, so that most people don't get that. I ask that in court, even if it's not checked in the petition. If you're an animal lover, you love this part of the new portal. And then are there any other requests? I'll just say this as an overview. You have to put any information in the portal that you want the judge to see or do. If you don't put the information in your petition, we can't do it. And I'll talk about this in a minute as well with the incidents. But if you don't, with the exception of firearms, if you don't put the information in the petition, the judge can't grant it. And it's not because we don't believe you. It's because it has to be in the petition for us to grant it. The reason behind that is that if we grant the petition, then that's going to be served on the defendant. And that is the only notice the defendant has of what is against him, due process. That's what he knows you have said. If we grant it on testimony that is other than what's in the petition, the defendant doesn't know what other grounds we've granted it on. And I'm going to emphasize that again in a minute. But that's why this question, any other requests you are asking the court to protect you from, you've got to fill this out as well as you can. All right, next slide. Additional persons, next slide. So this gets people into a bit of trouble, but again, I'm going to say, fill it out. If there is another person that you want covered, just put them in there. The statute, as Ms. Polk pointed out, for other adults is, people put this in there all the time. Please put it in. If you don't put it in, then we can't grant it, but we'll probably talk to you about it. If it's another adult, that adult has to be permanently or temporarily unable to request for themselves. These are individuals such as older people that the plaintiff might be taking care of. It can be a disabled child that's of age. So those are the other adults. I have seen fully able adults being put on requests for petition for order of protection. That's not something that we normally grant. That person could come in and get their own order of protection. So we see that, I see that a lot. Again, put it in there, but expect to be asked questions if it's another adult. If, again, there are children, we will ask a lot of questions. And the reason for that, I think I said this earlier, is that then if you have a child with the other person, then that effectively means the other parent will not see the child for a year. So we will ask a lot of questions about that. And then yes, next slide. Incident history. This is where this all comes in. Next slide. This is the most important part to a judge of filling out the petition. You have to take your time. I know people are scared. I know this, we know you're scared. We know this is hard. We really do. You have to fill out these incidents as specifically as possible. And it has to be, this is the incident. This is what happened. Use the cuss word, please. It's fine. There is nothing a judge hasn't seen or heard. So this, to me, is one of the most important parts of filling out the petition, because this is where the judge looks to grant the petition. This is the only thing the judge really can look at to grant your petition. It has to be very, very specific. Please don't put financial issues, property issues in this point of the petition. Those are not reasons a judge can grant an order of protection. That is part of a family law case. We need you to be very specific. Remember that the judge has to find that there is reasonable cause to believe that the defendant has committed an act of domestic violence in the past year or will commit an act of domestic violence. Financial and property issues are not considered crimes under the criminal statute that we have to use. Also, it shouldn't be about, he told me yesterday that he's going to keep the children from me. That is also better handled in a family law case. So I just want to emphasize that this is where you need to really be detailed for the judge. I don't care if it's the date it happened. That's why this ingenious box is there that says this is an estimated date. Most people, I don't remember what I had for breakfast this morning. So we understand all that as well, but please be as detailed as you can. Next slide. And this is one of my favorite parts of AZPOINT, is this need help button. It's ingenious because you don't have to just like fill in the thing and then just go to the courthouse. Look at the need help button, and it absolutely tells you this is what you want the judge to consider. Use that help button. It's next to the safety button, this is like the most amazing part of this portal. And it tells you will only be able to talk about events you describe. We also understand this because when you come into the courtroom, and we really do know it's intimidating. We try really hard not to be, but we understand. Most people don't come to court. We do this every day. We don't, so we get it. What normally happens though is someone will be in court and I will say to them, this incident that happened on February 8th, 2020, can you tell me a little more about what happened that day? Because here's what your petition says. And the next thing you know, they're talking about something that happened in 2017. We also understand that victims of domestic violence have a lot of trouble with recalling events. And we know that. We have all been to training, read books. We understand that victims of domestic violence have trouble recalling dates and have trouble putting things in order. But if you'll just give us a chance, we will try to help you with that. But we really can only consider what's in the petition. It makes us crazy too, but that's what we have to go on. Next slide. And so this is where we're going to talk about actions. Please take the time to review. As Polk said, you have 90 days. If you are in a serious emergency situation, come on in. We will figure it out. That sounded wrong. Obviously, you're in an emergency situation. But if you can please take the time to review your petition, ask yourself, if someone read this, would they understand what I'm saying? Right? So take the time, please take the time to review. Next slide. Service. This is really, to me, first the victim filling out in this portal, and then the service aspect. Yeah, next slide. 53. Oh, yes. This is actually one of the, to a judge, one of the best parts of how this has changed. When a judge grants an order of protection, well, I call it going whoosh. I know that's weird, but it just goes automatically to law enforcement through AOC. That is far better than having the plaintiff go to a law enforcement agency with their packet of papers and asking someone to serve it. For orders of protection, law enforcement will serve the order of protection. Right now it goes by zip code of the defendant and that law enforcement agency. Please make sure, as Ms. Polk said, to give a good number. Most of our law enforcement agencies here, actually all of them that I know of, will give you a call. Understand though that we don't know when it's going to be served. So when I tell people, I granted this, I try to explain to them, it could be served today, it could be served in a couple of days. If it's not served within 15 days, law enforcement is required to call you, all right? There is an exception to all of that. One of the things that I always ask is, if you are not comfortable, because this is going, right? If you're not comfortable, and I always ask, do you have a safe place to stay? Do you have a safety plan? And I ask that because a lot of people don't. So I can hold, any judge can hold service for 24, 48, or 72 hours. If that individual needs to get a safety plan into place, needs to talk to an advocate, which thank God for advocates, so that it's not served right away and they are caught in a situation that is dangerous for them. So judges do have that ability. I always ask that. But for the advocates that are listening, that's also something that is new. since January that you could also ask your clients about. A couple of practical tips. Please stay at the courthouse. We will interrupt our entire calendar for you, and we don't mind. We get it. We want to hear it. In Yavapai County, we will hear you the same day, no question. We will try to hear you within a couple of hours, if that much. But you have to stay. Lately, we have been having a lot of plaintiffs file it and leave. And we may try to contact you if you have a good number. We may not because we're in court. So I can tell you my division tries to call people. But we had a couple last week where we couldn't get a hold of them. Understand that we are under rules that require us to adjudicate orders of protection within 24 hours. So please stay. We've had, for whatever reason, we've had a lot of problems with that lately. When you come to court for your order of protection, the clerk will ask you for identification. So please bring a form of identification. As Ms. Polk showed you, you'll be a number in the system. And we don't know if that's actually you. Far be it from me to suggest that people actually file orders of protection against their own wife pretending. Also, people try to file multiple orders of protection in multiple jurisdictions. And so please bring your ID. Make sure that the defendant's information has an address, not a PO box. They can't serve to a PO box. It has to be an actual address. Next slide. Other things about service. As I said, it will go to law enforcement. Please fill out the part about where the defendant may be located. A couple of, if this is an injunction against harassment, the plaintiff has to serve. When we say the plaintiff has to serve, that does not mean the plaintiff goes and finds the defendant and gives them the papers. That has happened way too often. So they need to provide a way of service, and the plaintiff will have to pay for it if it's an injunction against harassment. A couple of tips. We cannot put hospitals as a protected address or somewhere where the defendant cannot go. That situation arises when the plaintiff is a nurse or works at a hospital. We can't prevent someone from going to get help at the hospital. It comes up more than you would imagine. The other issue is if both of you work at the same place. That also happens quite a bit. It's an iffy situation if we can keep someone from going to work. So expect judges to ask you if you work at the same place. It's not that we can't do that, but it's problematic for reasons I'm sure you understand. We also can't put the park or our park or public places that are like that. I've seen people put the Walmart that I shop at. And the problem with that is that's just too specific. I mean, it's too broad. I'm sorry, it's too broad. I mean, I don't know when you go to Walmart for your shopping. So, and I always tell people too, at least in Yavapai County, this is a very small community. So you're bound to see each other at some point. Both of you need to walk away. Next slide. I've already pretty much talked about this. Another tip, if you know the defendant is in jail, please tell the judge. Because if he is in jail in Yavapai County, we do have a special number where he could be served in jail, and it's a whole lot easier. And we will send it to the jail for service. Next slide. I've already gone over this extenuating circumstances language, which is new. that the judge can hold the order of protection for anybody to make a safety plan. Next slide. This is the proof of service. Once service is affected, the law enforcement agency has to file that proof within 72 hours. And again, if they have not served it, they must contact a plaintiff with, if they haven't served it within 15 days. Another really good part of this legislation is that the law enforcement must attempt service for a year. In the past, law enforcement has tried to serve it a few times and then it kind of falls off the radar. So they will, they have to try and serve it for a year, which is also awesome. I always tell people, and I'm sure the advocates also do this, but I always tell them that the most dangerous time for a victim is when the petition is served. In a dangerous situation, it makes people very angry. And so I always try to tell people this is the most dangerous time is when the petition is served. And I try to tell them, make sure you're safe, make sure your kids are safe. You might not want to stay at the residence for a few days. So, and to the extent that there are advocates on this presentation, I cannot thank you enough. And I know Ms. Polk is going to go over this next. We have pamphlets from several different agencies in Yavapai County that we give out. And I just cannot tell you how much we appreciate you here. You guys do amazing work. It's so necessary. And we just appreciate you. Next slide. This is what I was talking about with injunctions against harassment. And this slide also does point out that if you have an injunction against harassment with a dating relationship or sexual violence, that will be served by law enforcement. Otherwise, you have to pay for that. The same rules go for a plaintiff that has injunction against harassment. They must file proof of service within 72 hours. And the Supreme Court or the Administrative Office of the Court is the central repository for all of this. This also is super helpful because it gets into NCIC faster so that law enforcement is aware. And I kind of didn't talk about that as much, but the more information you have in your petition, the more safe it is for law enforcement as well. I often will write things that are put in the other category, like prohibited possessor, felony, whatever it is that the defendant has, so that law enforcement is aware and they can be safe as well. All right, Ms. Polk.
Well, thank you, Judge Hancock, for that excellent presentation. And I'm sure there's going to be lots of questions follow up, particularly for you. I just want to wrap up by talking a little bit about how can you, if you're law enforcement or if you're a victim advocate, how can you help? And I'll echo the words of Judge Hancock in talking specifically about our victim advocate community here in Yavapai County. They are phenomenal. And it's whether you're a prosecutor in a domestic violence case, whether you're the judge who's handling these requests for protective orders, our ability to hand out information to victims about where they can get services right in our community has really helped us keep this community safe. And so huge kudos to our victim advocate centers and the work that you do to help these victims. Here's just 5 things that we've identified that you can help do. The first is to spread the word about AZPOINT. I think word is slowly getting out there, but whether you are law enforcement, whether you're victim advocate, whether you are another profession, just let folks out there know. You could just be a friend, a relative of a victim who's in a domestic violence situation. Help spread the word about AZPOINT. It is a phenomenal tool. I hope you agree after sitting through this presentation. And the more people that know about it, the more people that learn about it, the more people that use it, the safer we are as a state here in the state of Arizona. In particular, Judge Hancock talked about the new service feature, where when we're looking at orders of protection, once the judge grants that order, that's a huge change for victims in Arizona, where in the old days, in addition to all the trauma, all the fear, all the unknown that they were facing, they had to be the ones to take their petition to law enforcement in order to get it served. The fact that now through this system, once the judge grants the order, sets out that timeline for service, they can, as Judge Hancock described it, this whoosh system, where it's now going out to law enforcement, to the appropriate agency to serve, is huge for the state of Arizona. You can help by explaining the changes in that process. And you can also help, now that you understand the difference between an order of protection, injunction against harassment, you can help spread the knowledge about that as well. Safety planning is so, so important. I think everybody on this webinar probably understands that, but I think help spreading the word about how important it is to safety plan for that victim before they actually go into court to file that petition. Have that safety plan in place. The victim needs to understand where he or she will be, particularly in this early stage, particularly at the time of service. If there's children involved, where would those children be? And what is that short-term and long-term plan for physical safety, for financial security? What is their plan if something is happening? Are they ready? Just that safety planning before you actually go to court and get that petition from the judge, have that safety plan in place. And then talking about whether or not, if you're in the early stages with a victim, perhaps a friend, perhaps you're an advocate, but always looking at whether or not that order of protection should be part of that safety plan. And then for law enforcement, you next are going to hear about the lethality assessment, but just making sure that you and your organization are conducting those lethality assessments. I think you'll really like the next part of this presentation when you learn about the development of the lethality assessment, how easy it is to administer on the scene, and how important it is to ensuring the safety of the victim. I think you'll understand why it's so important to always conduct that lethality assessment in a domestic violence situation. If your client wants to apply for an order of protection, here's the next thing you can do. The nice thing about this portal, AZPOINT, is that you can help them go through. You've now seen how it works. You know what's going to be asked. You can help prepare your client for this process, and you can sit right beside them and help them go through this online interview. If necessary, help that client obtain a new email address if they want to use a different email address, for example, for notification about this process. And then discuss with the client just the circumstances around filling out this petition, specifically computer safety. Where will the victim receive either email or text notifications? How will the victim be in a safe place when you're receiving those notifications? And then discussing, you saw that a password is needed for this system. It is password protected. But again, thinking about where will that password be saved, and is it being saved in a safe place where the abuser won't discover it? And then of course, legal advocates can help draft the allegations for your petition as well. And then our final screen is just where to find help. So in Arizona, finding a victim advocate. We have an organization called the Arizona Coalition to End Sexual and Domestic Violence. These are some phone numbers where you can go to get help. National Domestic Violence Hotline, we put the number on here. There is a link to domestic shelters, domestic violence shelters, and then there is the Hope line as well. In Arizona, only an attorney who is licensed can give you legal advice. And so we put here the contact for the Arizona State Bar Association and how to find legal help. And then our final screen are just some more resources. We talked a little bit about how in Arizona, the addresses are confidential. That's actually a wonderful program passed by the Arizona State Legislature and made even better through additional follow-up tweaks to the legislation. But our program, it's called the Address Confidentiality Program, is run through the Arizona Secretary of State, and it actually allows a victim to protect a home address and create another address, which is a decoy, not the real address, but still be able to do business with utilities, receive your mail, etc. It's all about protection of the victim. We have on here the court system, the self-help center for all of these orders, and it's called azcourthelp.org. We put on here a link to things you should know about protective orders, and then a link to safety planning. It's a really nice website, which if you're trying to help, whether you're an advocate, whether you're a friend, whether you're a relative, whether you're law enforcement, helps you understand all the different aspects of safety planning that maybe on your own you wouldn't think about. And now that is the end of the formal presentation. We are ready for your questions, and we have Ray, I believe, is going to ask questions of the two presenters.
Of course, and thank you, Sheila and Judge Hancock, for your excellent presentation. Very insightful for the innovative tool AZPOINT that we use here locally in Arizona. We do have a few questions. One of the first questions we received was what language is compatible with the AZPOINT software, and I think this goes into two pieces. I think the actual website that you're accessing it, you can still use like a Google Translate or another web extension to change the language on the outside, but the tool itself, I don't know who would be able to answer that better. Would that be Sheila?
I don't know the answer, so I hope Judge Hancock knows.
I do know. It is available in Spanish and English right now, and that's all we have. But as Ray said, and I also believe that I know at least one of our advocate centers does have the ability to translate, as Ray said, through the internet. It can translate for them.
Great, thank you. So we have another question here, specifically asking about prohibited possessors. So can we place information on the defendant being a prohibited possessor in the incident history as like a note, so within inside the AZPOINT software?
Absolutely, please do.
Thank you. We have another question here. What will the court do to ensure the victim that the respondent will not be able to keep his firearms? And I'm guessing this is in the process of the order of protection.
So there are two different, well, let me start with this. When you come in initially to get an order of protection and you have checked the weapons box, or that you have told the judge after the judge has asked you about the weapons, there is actually a state law, and it's tied to a case called Emerson, which is actually a federal case, but never mind. So with the ex parte, which is the one you come to get initially, the judge can order, and if there are weapons alleged, I almost always order that the defendant cannot possess or purchase firearms and cannot possess or purchase ammunition. And then I also order the defendant to turn over any firearms or ammunition they have within 24 hours of service to whichever is their local law enforcement agency. And those are orders of the court. The purchasing and possessing of firearms or ammunition will go into the system. And so technically, until he's served, that doesn't go into the system. But after the defendant is served, it does go into a system. And if that person were to try to purchase firearms or ammunition, there would be a flag. Obviously, if they try to buy firearms or ammunition not from a gun store or wherever, they would be able to do that. But that really is the best that we can do.
Great answer. I agree. So our second to last question is if someone has an order that is expiring and they want to request that order to stay in place for an additional year, is there a form in AZPOINT that they can fill out? If not, what does that process look like?
So orders of protection are good for a year in Arizona. And so what you have to do if it's expiring and you wish to have it stay in place is you need to file another petition, and you have to fill out again the incidents. If this person has not contacted you and there is no more contact, that will be difficult, because remember, what the judge has to find is that there is a reasonable belief that the defendant has committed an act of domestic violence in the past year or will commit an act of domestic violence. So if the person has abided by the petition for order of protection, that's going to be difficult. But let me give you another example. So assume the defendant has been convicted of domestic violence, aggravated domestic violence, and this person was the victim, or there were children were the victim, and Ms. Polk has prosecuted that case, and that person has been in prison for 2 or 3 years. That is a different scenario, because this person has been in prison and they're about to get out, right? So that person had an order of protection for the past year because that's when the case was going on, or even a couple of years ago. That situation, depending on the facts of the case, could result in a judge granting or renewing, but it has to be a separate petition, granting another order of protection based on that person is getting out, this is what happened. And Ms. Polk can tell you this too, I've seen egregious, horrible cases where this person is getting out of prison, where the judge can find, based on the specific facts of the case, that this person really does need another order of protection. So it's really based on the facts of each case. So we do look at the facts of each case, what is happening, and where, what the facts are. I've had cases where they're in prison, getting out of prison, and the defendant has not contacted the plaintiff personally, but they've gone through third parties, or, the defendant's mom is contacting, stuff like that. So, or through third parties. So we really have to take the facts of that individually and look at it. So yes, you can get a new one, but it really depends on the facts of the case.